Mm.
If I'm praying for leave to file mapping without certified copy.
When was the order passed?
Order was passed in 1st December, 3rd December we have applied, but we have not received yet.
What is the
Agency lordship, it is regarding dismissal from service.
then there is no urgency. Obtain the
He
certified
is not
copy.
getting any money, lordship hears out. He is not getting his salary, lordship.
Get the certified copy and file. There is no urgency, sir.
Lordship, even that, it will take some time to bring
No,
it to
no,
your
no.
lordship after even filing.
Sir, that cannot be the usual procedure.
I understand.
Wait for a week. If
I
you do not
understand.
get, then come to us. Yes.
Grateful.
My lord, assigned matter, my lord. It was heard by your lordship in the last month. On 9th, my lord, it is directed to be posted. But the 9th, the matter was not listed. But section 5 application and stay applications. The mutation matter, my lord.
Give this.
Upon notice, I am mentioning. Upon notice.
বলছে 9 তারিখ আসার কথা ছিল। Was there any order to that or verbally?
The order is not uploaded. Your lordship, my directed.
Verbally
Verbally,
directed.
yes.
একটু দেখে নিও তা দিয়ে দিও। Yes, call the list. কি হয়েছে আজকে? One. Yes, who is there?
Cannot to be mentioned.
Why to be mentioned? Are you there? In item 1 you are not.
No, okay.
নিশ্চয়ই complete হয়।
Not this week. Affidavit আছে।
Not this week.
Number 2.
May it please your lordship. But I'm for the petitioner, my lord. But pursuant to your lordship, am I audible to your lordship, my lord?
Yes, yes.
My lord, pursuant to your lordship's, my lord, earlier direction, my lord, we have served upon, my lord, the learned district inspector. I'm sorry, the district inspector, my lord. And I'm not sure if someone is appearing, my lord. But this is my lord, my application for contempt. If your lordship, my lord, kindly sees the order.
Order dated?
My lord, that your lordship will see. Yes.
What happened? No decision taken?
My lord, decision is taken. My lord, if I request your lordship to see, my lord, page number 32 once. My lord, there has been a legible copy, my lord, which is appended, my lord, just after page number 32. My lord, if I request your, I'm sorry.
Just a moment. Yes, what is the content, Mr. Roy?
If Lordship has seen, my lord, the order dated 6th of June by the district inspector, my lord, there, my lord, the fourth paragraph, my lord, the last but one paragraph from the bottom, my lord, last but two paragraph, where, my lord, it is said that they did not find any willing teacher. So, my lord, all, my lord, I was just trying to, my lord, impress upon your lordship is that your lordship's direction was to, my lord, follow 3rd of January. My lord, 3rd of January, my lord, never, my lord, talks about this willing teacher requirement of a willing teacher, which is already, my lord, held by this honorable court in several judgments.
Then what can be the procedure? What
What I was just trying to, my lord, impress upon your lordship, my lord, if the direction of this honorable court would have been, my lord, properly complied with, they would not have, my lord, taken this point of willing teacher, my lord, concept of willing teacher, because my lord's direction was, my lord, to,
what can be the solution? Suppose they don't find a teacher.
my lord, in that event, my lord, this has been, my lord, already held by this honorable court, my lord, this cannot be, my lord, kept in limbo for, my lord, indefinite period.
What is to be done? So there
My
has
lord,
to be
your lordship, my lord, post, my lord, a specific time frame, let us say, my lord, for 6 months, 3 months, for the purpose of finding out this teacher, and if it is not at all found out, since, my lord, the right is already accrued, my lord, to the petitioner, or by dint of this, my lord, rule, my lord, his or her case is, my lord, forwarded. If I just request, my lord, my learned friend who is present before you,
Yes, we are in contempt. You are saying that willingness is not an issue in that circular. Very good. Now, what can be the practical solution? Suppose can the DI pick up any person from any school and say that you work here so that he can go?
but the solution subject to lordship, my lord, which is already, my lord, clarified by this honorable courts time and again, that if any willing teacher or if any teacher is not, my lord, found out, in that event, my lord, the application for the transfer is forwarded, my lord, irrespective of the fact if someone is found out or not.
Where is that provision under the
There is subject to lordship correction, or there is no, there is a gap, my lord, in the rule. This is why lordships have interpreted this situation. If I request your lordship, my lord, my learned friend, my lord, to hand up your lordship.
interpretation was willing? That willing term is not there. We have interpreted that willing, but I am asking that what can be the practical solution? Today the DI cannot on the dint of this order pick up somebody from any school and place it here. What can be the solution then?
Manad, what is, Manad, done usually, Manad, in these matters, Manad, after your lordship's several, Manad, directions, that if they, Manad, in a particular, after a particular time frame, if it is not found out, they, Manad, anyways, Manad, forwards the application. And, Manad, the rule itself, Manad, provides a provision. I'm sorry, so sorry, Manad. If, Manad, at least they could have, Manad, appeared to your lordship, Manad, they would have, please.
No, did we do away with that term willingness in the order?
No. I'm sorry, Manad, no.
Then, Mr. Roy, it has to be a fresh writ petition. No?
Manad, Manad, my only, Manad, pray before your lordship that if your lordship's order, because what is there in the rule, it is there in the rule, Manad. That
So an order has been passed. You challenge that in the order. When you will challenge, you take those grounds of willing interpretation before the court.
But Manad, if as your lordship pleases, Manad, only, Manad, my request to your lordships previously, Manad, was that if that would be, Manad, and another exercise of, Manad, several months, because we have been my application.
In our order, we have said
Follow,
that
Manad, follow.
considered terms of 3rd January. We have not
Follow, Manad.
said anything else. So when a decision has been taken, Mr. Roy, further interference in contempt does not occasion. You will be at liberty. We will say that you will be at liberty to file a fresh writ petition.
Manad, I'll do that, Manad. Before that, only, Manad, though, Manad, it is a judgment of the honorable single bench. If I just could hand up your lordship, however, Manad, I'll just.
You have to go, Mr. Roy.
I'll do that, Manad. May I just get the liberty, Manad?
Dated 14th March 2024, passed in MAT 341 of 2024. By that order, the petitioner's application for transfer was directed to be considered by the concerned district inspector of schools. In the light of the provisions contained in the circular dated 3rd January 2022, upon granting an opportunity of hearing to the appellant, petitioner, appellant, and the school authority, and to communicate the final decision to the applicant. Pursuant thereto, an opportunity of hearing was afforded to the appellant and the school authority, and a written order was passed, and the same was duly communicated to the appellant also. Mr. Royal Learned Advocate, representing the petitioner, referring to the certain portion of the written order, submits that the petitioner, that the appellant, where the transfer has been turned down on the ground of non-availability of willing teacher. He submit that
Peter has been turned down without specifically following.
has been turned down without specifically following the provision contained in the circular dated 3rd January 2022. So affidavit সার্ভিসটা প্রথমেই নিয়ে নেব। However, since in compliance with the order dated 14th March 2025, a written order has been passed. A written order has been passed. In view thereof, we are no longer interested to proceed further with the present contempt application, and accordingly the same is disposed of
With liberty
to the petitioner to
challenge the said
the said order in the event he feels aggrieved thereby.
Yes,
So advised and in accordance. So challenge the order dated such and such before the appropriate forum, if so advised and in accordance with law. Disposed of. Yes.
Special Lordship, great for me.
Do you have that affidavit of service?
What was why the witnesses are not coming, my lord? That also.
Yeah.
I'll just check, my lord.
For the applicant.
Yes. I
My item number 3. Writ petition for framing of.
Yeah, just one moment.
I'm sorry.
Any section 5? It is coming for the first time.
For the first.
Have you served, Mr. Yes, Mr. Chunwan.
My writ petition challenging a program guide for imparting education in a bridge course in relation to DLED through Bengali medium was dismissed. Therefore,
Just your application.
pursuant to a direction or an order passed by the Honorable Supreme Court, it was held that DLED is the necessary eligibility criteria, is the necessary qualification required to be possessed by a teacher for the purpose of imparting primary education. It's not B.Ed. Now, each state was directed to, NCET was directed to frame bridge courses, 6-month bridge courses for the purpose of imparting education to the teachers in each state. Now, in so far as this state of West Bengal is concerned, imparting of education had been carried out in Bengali medium in DLED courses. So we requested that instead of Hindi and English, this should also be carried out in Bengali medium, because the provisions of section 29(1) subsection F mandates that it should be, as far as practicable, be imparted in a language which is local.
And also the Honorable Supreme Court has directed each state, not this scheme to be framed for each state, courses to be framed for each state. Now, this writ petition was dismissed on the ground that it was a policy decision of the authority and therefore it cannot be entertained.
So they conducted DLED in some other language.
Yes, in Bengali.
In Bengali. You wanted it in English.
In English.
Seriously, DLED করেছে. In DLED they conducted it in English, in Bengali. In this bridge course, we wanted this to be conducted in Bengali as well. But they have restricted it to English and Hindi.
Oh. Then how you have been prejudiced, Mr. Majumdar?
But please come to the program guide at page 203.
203. This is after the Supreme Court.
After the Supreme Court judge. 214. Contradiction. But this is the caption of that guide. Now please come to 214 straightway. 210. Please come to 210 and then 214.
Yes.
But the third paragraph at 210, the sentence begins with the words, a significant component of the course is the school experience which focuses on chapter planning and delivery across key subjects. Language 1, Hindi or regional language. So now this is Bengali insofar as the state of West Bengal is concerned. Language 2, English / other than language 1. Mathematics and environmental studies. Teachers are required to document their experiences through portfolios incorporating reflections, artifacts, community engagement activities, and the use of educational technology. Reflective journals further support the development of self-awareness and professional growth. Now please turn over to 214.
213.
214.
Yes.
The medium of the instruction shall be in Hindi and English language. The first line on that page.
However, teachers are allowed to write
the public examination theory in any of the 22 scheduled languages listed in the 8th schedule.
So this public examination theory is in that bridge course.
There are, yes.
So you will get an opportunity to write it in Bengali.
I can write the public examination theory examination in my regional language.
Regional.
But in coming back to page 210, delivery across key subjects is language 1, regional language. Language 2
That is school experience. That is a significant component of the course is school experience, which focuses on such and such subjects.
Then
teachers are required to document their experiences through portfolios, incorporate reflection, artifacts, community, and the use reflective journals. So how this prejudices you, because they will be taking into consideration
imparting education in Hindi or English.
No, also in language 2. See, language 1, Hindi regional language, language 2, within bracket English, other than language.
It's either English or any other than language 1 subject.
Other than language 1 makes it includes Bengali.
No, it says other than. Please see, language 1, Hindi or regional language. For West Bengal, it would be Bengali. So language 1 is Bengali.
That is not illustrative. They are saying school experience has to be gathered from the key subjects which are taught.
So language 1 is regional language.
Regional. Language 2 is
either English or other than language 1.
That is Bengali. It may be Bengali.
No, it excludes the other than language 1. I can't take Hindi or Bengali.
It is component of the course.
Right.
Component of the course, language 1.
Please read this with
you are saying that medium of education or imparting education
would be Hindi or English.
But it is a component of the course, language 1, language 1 Hindi, and other regional languages must be Bengali. language 2, English or any other language other than language 1. Mathematics in the four components of the entire course. Each course 4 components. Now question is what would be the medium of course?
Now please,
Medium is page 100 and
214.
214.
The medium of instruction shall be Hindi and English language.
Now please come to section 29F of the RTI.
Our teachers are allowed to
Write the public examination theory. So, not uploading of the materials has to be in our language, that is the regional language.
And ODL
Although imparting of education is only in Hindi and English.
will be provided in Hindi and English.
No, Mr. Mojumdar, page 210, just clarify one thing. Language 2 within bracket English stroke other than language 1. So Bengali comes within other than language 1. In language 2 means English or other than language 1. So it includes Bengali.
No,
Language 1 is either Hindi or a regional language.
No,
language 1 Bengali.
It excludes.
এখানে language Hindi
Hindi slash
regional language.
In respect of Bengal, it should be Bengali. Now language
Excludes.
English,
Other than
after
language.
English or any other language other than
If I have selected, say, Kannada,
prejudice
then it excludes Kannada.
of instruction. That means you will be taught in English
And Hindi.
with liberty to write answer or appear examination in Bengali.
And I have to upload the
You will be
materials,
taught in English or Hindi.
and I will be uploading the materials only in the Bengali language or the.
You are at liberty to do so.
I'm not this. Please come to 214 once again. The medium of instruction shall be in Hindi and English language. However, the teachers are allowed to write the public examination theory in any of the 22 scheduled languages listed in the 8th schedule. The 6-month certificate bridge course in primary teacher education will be delivered through a ODL mode of instruction. The transactional strategies will include contract programs, school-based practicum, practice training, reflective journals, portfolios, video tutorial, e-learning materials, and digital platforms will be utilized to support flexible and effective learning. This approach ensures that in-service teachers can actively engage with the course and content while balancing their professional responsibilities. Not imparting education in 2 languages.
What was your prayer in the writ petition?
Please come to the prayers at page.
Now you people are already appeared in the exam.
In service teachers.
In service teacher, you have pursued your training.
Not yet
This
We have not yet registered ourselves.
19 is the last date.
Last date is 19. It's a 6-month course, a one-time exercise following a direct
bridge course. So you are not being registered also.
No, they are giving 2 options, either Hindi or English.
I can register myself if I opt for the languages of Hindi or English for the purpose of receiving
Yeah.
education.
No, if you opt for English or if you opt for Hindi or English, you will opt for English and the course will be taught in English, but you can appear in the examination writing in Bengali. What is the problem?
Please come to 214 once again.
Medium of instruction shall be Hindi and English.
Yes. Now please come to the next paragraph. Paragraph 10, mode of transaction.
Yes.
The 6-month certificate course in primary teacher education will be delivered through a ODL mode of instruction.
ODL means what?
ODL means
Distance learning.
The
transactional strategies will include contact programs, tool-based practicum. What is that? Practice training, teaching, reflective journals, portfolios, video tutorial, e-learning materials, and digital platforms will be utilized to support flexible and effective learning. This approach ensures that in-service teachers can actively engage with the course content while balancing their professional responsibilities. Now please come to the order at page 272.
270.
270. এইটা দেখলো তো। page 227 টা কোর্স তো। Now please come to 272, paragraph 4.
Sir, you participate in the English. If at all we are to admit the petition, the reasoning given by the judge is exactly what we have said.
Now
That
please
the
come.
medium of instruction will be in English or in Hindi. In the Supreme Court judgment also it was said 29F as far as practicable.
No, please come to the judgment of the Honorable Supreme
Now,
Court.
what interim order you want? We cannot say that you will be allowed to do the bridge course by opting for a Bengali medium. That procedure is not at all there.
That's why our prayer was to
So
induct this
Mr.
program.
Majumdar, this would topsy-turvy with the entire process.
No,
There is no hard and fast. We can say that you will appear, register yourself in English, you appear, and we will hear the matter. Your registration and everything will avoid by the result of the appeal.
why we are
At best, you can pray for that. But otherwise, Mr. Majumdar,
what
No, the entire course and the learning course also was nationally designed.
no, please come to the Honorable Supreme Court's order.
For each state, yes, the word each state most probably have been used. Now it is nationally designed.
Now,
Now,
this,
if the what is NI national, that authority is
Open
directed
school.
to prepare a module for every state. It would be inconvenient.
inconvenience of an authority, not a statutory authority, of an organization, has to conform to the requirement of a principal act. Now, please come to section 29 of the act, of this Right to Education Act. Now, we have undertaken
that is quoted in the order.
not really quoted.
Kindly come to page 271, paragraph 3, last portion. That
It's
was
only-
Mr. Bose's submission.
Yes, in essence, it is referred to.
Referring to section 29F, he submits that medium English shall, as far as practicable, be child's mother tongue.
Yes,
It
now-
is not that it has to be in child's mother
Now,
tongue.
please come to section 29 once. Not all programs have been conducted in Bengali insofar as this state is concerned. Please come to section 29. Curriculum and evaluation procedure. Now, this comes under the chapter of completion of elementary education. The curriculum and the evaluation procedure for elementary education shall be laid down by an academic authority to be specified by the appropriate government by notification. Shall be laid down. The academic authority, while laying down the curriculum and the evaluation procedure under subsection 1, shall take into consideration the following, namely, please straightway come to F. Medium of instruction shall, as far as practicable, be in child's mother tongue.
As far as practicable.
As far as practicable.
How can we say at this stage that you registered them for Bengali medium, though Bengali medium rider has not been set aside by the court?
No, it is not. Not
It's
our.
not. So at best you can say that let my admission, it may so happen that you will all be successful. We need not consider the issue at all, subject to what Mr. Banerjee says. Maybe you will participate. They are not saying that we are not denying you participation since your mother tongue is Bengali. That would have been something
No.
serious.
One has to compulsorily register himself in Hindi or English language. Now, please come to 255. Not previously for.
No, are you agreeable to such a proposition? Then we can ask him. If you say that no, you hear the appeal on merits on this, I will not appear. That is your risk and peril. Your risk and peril. We will invite.
Now, please come to only one document. Not why we have paid for this. But in so far as DLED is concerned, not the entire medium of instruction was in Bengali.
What conducted by
at
NIS?
259 and conducted by the same organization.
Consider
259.
This is part of my supplementary affidavit at page 255. 255 is the supplementary affidavit, 259 is the document.
কর্মসূচি।
Yes. প্রাথমিক শিক্ষায় দ্বিবার্ষিক ডিপ্লোমা, দ্যাট ইজ ডিএলএড, কর্মরত প্রশিক্ষণহীন শিক্ষকদের জন্য। Please see note who has issued this. রাষ্ট্রীয় মুক্ত বিদ্যালয় শিক্ষা সংস্থান, NIOS.
Yes.
That the fifth last line of that page 272, paragraph 4 of the judgment under appeal.
Yes.
It is expected of the teachers to understand English.
272.
Page number 3 of the judgment under appeal, paragraph 4, the fifth last line of that page. It is expected of the teachers to understand English. The course so structured by NOS does not affect the provisions of Article 350 capital A of the Constitution of India. He seeks for dismissal. Now, this expectation is also to be read with the judgment of the Honorable Supreme Court and section 29(2)(f) of the RTE
A
Act.
submission on behalf of the respondent in
Yes, that has been accepted.
Without calling for affidavit.
And without considering that even for the DLED course, the same authority had imparted education in regional language.
Para 8 is the observation
Yes,
of
upon
the
going through the program at page 170, it is found that the medium of instruction has been made in Hindi and English language. It is relevant to note that the teachers are allowed to write the public examination in any of the 22 scheduled languages listed in 8th schedule. Therefore, the petitioners cannot claim that they are affected by such program. One cannot be oblivious to the fact that the teachers have completed B.Ed examination and as such they are acquainted with the English language if not Hindi. Section 29(f) of the Act provides that the medium of instruction shall be the child's mother language as far as practicable. The aforesaid provision has nothing to do with the program which has been scheduled for the 6-month certificate course of the teachers. Thus, this court finds substance in the submission of the learned advocate for NIOS. Accordingly, the writ petition falls short of merit. Now, 29(2)(f) requires imparting of education in so far as practicable in the mother language of the child. And B.Ed was conducted in Bengali by the same authority.
University.
DLED, not B.Ed, DLED.
National Council of Teachers shall design such course under overall supervision of Ministry of Education.
191. No?
191. That direction.
Now, the course is yet to commence. The registration process will be commencing from 19th. Not permit us to register in any one of the languages as per the convenience of the teachers, and your lordships will decide the matter.
Sorry, Mr. Mojumdar. Ashok, the present appeal has been preferred.
I appear for the state response.
The petitioner filed a writ petition before the honorable court seeking two prayers that she may be allowed to seek for second SLST 2025 election test for appointment of teachers in 11 and 12.
Just. You're challenging the order
Honor of
dated?
Justice, on page 73 is the order.
Page 7. Yeah, give us 2 minutes, Mr. Ghosh.
Commissioner service which state is
Commission is there. You are
Well, commissioner is the material respondent. Commission is the
you are an
material respondent.
immaterial respondent, Mr.
Well,
Oh,
I'm,
your
immaterial respondent.
I'm material for other purpose.
You are for commission.
He is material.
We have not, I have not yet
You
received.
served,
the
Mr. Ghosh? Served?
Yes, Mr. Gui.
Hmm.
After service, your lordship fixed the matter. I am pleased your lordship that I have served. Then your lordship fixed the matter last Friday.
Then I have to take instruction, my lord, because in these matters, my lord, in connection with the second SLST, my lord, Mr. Bandopadhyay, Kalyan Bandopadhyay is appearing. My lord, in the writ also, my lord, he appeared.
My lord, our prayer, I hope, my lord, your lordship can interfere upon hearing me. Because
No, Mr. Ghosh, we can request you to make a further service and come back next Monday, subject to what you say.
my lord, in the meantime, the result will be declared. My client appeared in the
পরীক্ষা তো হয়ে গেছে।
second SLST, he appeared.
Yes.
The result was declared that you have been declared the tainted candidate. That is our ground that she cannot be tainted candidate. She
So
can-
very good that the Honorable Learned Single Judge has already insisted of a matter calling for names of the tainted candidates.
No. Here our case is that pursuant to the order passed by Justice Abhijit Gangopadhyay in Setabuddin's case, my client made an application. There, the court directed the commission to hear the petitioner and the other applicants. There, the commission heard the present petitioner separately and passed an order that his OMR sheet, his test, other marks in the other test, and also physical test, all the marks are there. He obtained 62 marks. So how the question will come that I should be tainted candidate when I have not given the blank MRC, when I have not appointed after the expiry of the panel, or after when I have not appointed out of the panel. These three criteria has been
Understand, Mr. Ghosh, immediate injunction is not required. This has to be heard.
upon his order is required that when he sat for the second SLST 2025 examination and his result was given as not as tainted candidate, that should be for the timing kept in abeyance and his result may be published. That will be abide by the result of the appeal before your lord.
Exactly, that order can be passed also in their presence.
Yes.
So we will only hear them.
Well, the order under appeal says the written test of the selection was conducted way back in September 25. Result thereof has also been published. At this stage, there is hardly no scope to entertain the writ petition and it is dismissed. That's page 73.
Where B was to remove the tainted candidate which has been declared by the commission.
অর্ডারটা দেখুন ফার্স্ট প্যারাগ্রাফটা দেখুন
Instead, writ petition has been filed in April 25, seeking permission to appear in the selection process.
আপনি বলছেন অ্যাপিয়ার করে
Page 73 that Mr. Ghosh was showing to your lordship.
My lord, one page I shall show you, lord, kindly see.
There
Page
is-
33 or running page 56.
Mr. Ghosh, your
Ghosh.
prayer was to allow you to sit in the exam.
Yes.
Prayer A.
Yes.
And prayer B was
To
that,
remove me from the tented list.
yes,
That
because
was not at all
Aha.
considered.
you will not be allowed to appear in the examination unless your name is removed.
Yes. Yes, yes,
That is why these two prayers were made.
yes.
Now the examination itself is over.
Yes.
So question of removing your name is an infractuous issue in this writ
Yes.
petition.
That's it, ma'am.
You was,
বুঝে গেছি।
she appeared in 2016 selection test in classes 9 and 10.
আমি অ্যাপিয়ার করেছিলাম
Rightly or wrongly, she made an application for 11 and 12 in second SLST 25 examination.
এই তো,
You made
তুই ছিলে তো।
হ্যাঁ
For the second LST of 2025.
For 11 and 12 in,
Oh, for 11 and 12.
Nutrition.
in nutrition.
11 and 12 classes in the subject of
Nutrition.
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 Earlier it was
You are
life
in
science.
nutrition, Mr. Ghosh. Subject of nutrition.
Yes. My lord, that was allowed by the commission. I was called for a written test.
Hmm,
I sat for the written test.
very good.
Thereafter, I called for verification test.
আছে কিছু
Then when result they should declare, they said that since you are a tented one, so you have been, you can say your application, your result.
In you were a tented one in respect of 9 and 10,
9 and
not in respect of 11 and 12.
12.
So where is that order of the commission?
Well, what order of the commission is at page 56, running page 56 and annexed P10 of 33 of the petition.
PC.
56.
56 or 33 কি হতো
33 দাঁড়াও না, তুমি একটু দাঁড়াও না, হেল্প করো না।
আমি তো হেল্প করার জন্য আছি
Always you are for help.
So what did the commission say?
Commission said, well, kindly see,
Now then what is the examination of 17th April in which you wanted to participate? That is the second LST 20.
25.
Then why you are saying that you passed in the written test, verification was over?
He made an application for appearing second SLST 25 for nutrition 11 and 12.
Right, for that examination was on 17th of April.
25.
Very good. Then why you are submitting that he was passed in the written test, verification attended?
Subsequent development, I made supplementary affidavit. In the writ petition, when I filed the writ, there is a need of permission to sit for the examination. That's why PRA was there. Subsequently, when my application for class 11 and 12, second SLST 25 was allowed, I made supplementary affidavit annexing all those documents. That
You did not participate. You were not allowed to participate.
I was allowed to participate selection process of 25 in nutrition class 11 and 12.
Selection process includes written test and personality
Yes.
test. Did you appear? You were not allowed to appear in the
I appeared. My selection. No. Kindly see supplementary affidavit.
But where is your supplementary evidence? We don't have.
Supplementary was considered by the learned judge. We have given the supplementary affidavit.
Page,
60. Yes,
Page
60.
60.
have you annexed the earlier order of the court, 16th of December?
16 days on the दिन.
Compliance of their hearing.
December order date.
It is we mentioned. Here is the order.
Past SLST examination 2016, you appeared for the class 9 and 10 and is secured,
Subject was life science.
subject was life science. You secured 62 marks.
Yes.
There are other candidates who also secured similar marks.
Yes, 62 marks.
Similar. All are senior to you.
Yes. So far as the rank is concerned, I am
Considering
not
this fact, your name was placed at the bottom.
bottom.
Among them.
That I am not-
Among them.
Yes.
that I am accepting.
Yes.
I am accepting. So far as rank, I am not any disputing. My rank was correctly given.
Yes.
My rank was correctly given because I was junior most. Senior pass, those who have obtained 62 in SLST 2016, there my name appeared as a empanel candidate. I was given appointment. I joined in 2022. I worked up to March 2005. 25.
Given appointment in which
Madam,
procedure?
In SLST 2016.
For the subject of life
Life
science.
science.
which was cancelled.
Which was subsequently
Baba,
cancelled. Subsequently
একই
cancelled.
চাকরি চলে গেছে কেন ইয়ে করছো বসো?
Subsequently cancelled. He 20 up to March 25. He worked. He got salary. He got salary.
So now when the second SLST was published,
Yes.
you wanted participation in the subject of nutrition.
Nutrition.
Then why did not allow you
They allowed me.
in the 2025 process?
They allowed. When the result came, they said
You participate in the examination of 17th April.
yes.
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 So why is your prayer to allow him to participate?
At that time, she was not declared tented.
Did you participate on 17th April examination?
Yes. Page 65.
Page 65.
Page 65.
So your writ petition prayer was allowed.
Where he was allowed by the commission.
No. When necessary, so that your prayer is so that you can be allowed to sit for the fair selection procedure as directed. Very good. Now you were allowed to participate.
Yes.
Then what happened?
Then when the result they declared, page 69.
Page 69.
Yes. But the number is there, everything is there. This is the SLST 25. Kindly see repeat test examination result.
Declared on 7th November 25.
Yes.
What?
Then rejected, being the tented candidate in respect of first SLST 2016.
Oh.
If after Setabuddin's case, the commission got my OMR sheet, got the every result of every stages, and totaling 62 marks. Not only me, 8 or 9 persons got 62 marks. Then how I should be tented? Because Justice Somensen's division bench and Justice Bosak's division bench said 3 qualifications. One is out of panel appointed, after expiry of the panel appointed, and blank OMR sheet given. I'm not.
That we are not interpreting.
No.
Whatever their lordship says, it is their business, not our interpretation.
Not falling after within the 3 categories. So how I should be declared tented? That is my question before your lordship. That is my petition before your lordship. Kindly record and take a decision upon hearing them. Yes. How? Why you are?
So after this page 69.
Yes. That is in supplementary remit I shown before the trial judge, which was not considered at all.
No. This when was the examination held? Second SLST?
25.
Date.
14 September.
14 September. 25.
14 September 25, you appeared.
Yes.
And
yes, kindly see page 65. By my admit card. My admit card. There the examination date 14 September 25. Then my OMR sheet, which was handed over to me, 25, page 66. And my lord, recently Supreme Court passed order that your lordship can certificate. My lord, kindly see 2 judgments of the Honorable Supreme Court where
challenge against this page 69.
Rejected being a tainted candidate in respect of such and such.
That was in a separate subject.
That is separate subject.
That is 9 and 10. Yes, any matter is pending on this.
My lord, let me come back, my lord. I don't have any instruction regarding this matter, my lord, since I appeared in.
But how can you reject his candidature
my lord, kindly attend this matter.
when he appeared in a different subject in the earlier selection process?
My lord, let me take instruction. I will inform my lord whether they have claiming that they have served. My lord, I will.
No, that
inform
is
the
not.
commission and all take.
I have submitted my lordship.
So why did the court say Written examination was conducted, so very good.
As per my first.
As because
when
of the
I got
the
the-
prayer of the writ petition. Prayer of the writ petition is subject to correction.
Prayer also I misread. Prayer is that you
Yes.
allow me to appear in the examination in terms of the Supreme Court direction of 17th
Why?
April.
But he has already sat.
He has already said, but now you are excluding him that you are tainted. Go
Tainted.
home. How can you do that?
The tainted list prepared by the commission, whether it was placed before the Honorable Supreme Court.
না না tainted. It's never placed. এখন তো অমৃতার অর্ডারে বেরোচ্ছে আর this order is then not sustainable. It has misdirected itself.
Kindly
Court.
take up this matter, my lord. Kindly adjourn this matter on the next date, my lord. I will come back, and my lord, I will also inform because my lord, Mr. Bandopadhyay, my lord, Mr. Bandopadhyay is appearing in this matter, my lord. Let him, my lord, appear.
Affidavit of service as file be kept on record. Heard Mr. Ghosh learn.
Led by Mr. Fiddosamim. My senior is appearing before the Honorable Supreme Court, my lord. For that reason, I am praying for the not today, my lord.
Honorable Supreme Court, so he will not appear.
No, my lord. I'm praying for the not today, my lord.
When did you join?
My lord, 6 months before, my lord.
staying before the Malat's single bench, Malat by filing a second writ petition, Malat to participate in the Malat recruitment process on the strength of the Malat the impugned order.
Which order?
Malat the impugned order before your lordship today.
Our order?
No, today Malat the
Order under
order of Malat under appeal before your lordship today.
A candidate of OBC category and to give him all
Page 46 of the Malat stay application.
advantage of a reserve category candidate.
He was declared OBC.
Malat by the court.
Oh, please place grievances. He could not produce the OBC certificate.
Malat he applied as general category candidate.
He had no option because he did not have that certificate.
At that point of Malat, the settled principle of law, as your lordship Malat, the also your lordship has Malat decided the issue, and Malat, the I am armed with the Malat the coordinate bench order. But the same Malat the TED examination, Malat the similar circumstances, the pat on the point, Malat that the when he appeared as general category candidate, at the time of Malat notification, he had not the OBC certificate. Now he cannot claim Malat the OBC Malat or take the benefit of OBC Malat.
Now, whether 4 months time was granted,
Malat.
the order 4 months reason the for the reason that certificate was not given by the stipulated time, that is 4 months from the date of the notification. Whether in the notification 4 months time was given.
Malat he Malat applied belatedly.
7th of July 22 was the notification date.
Malat, I tell you, lordship, the notification, TED notification is Malat 29th September 2022. TED notification, TED 2022 notification. Malat, he applied for OBC Malat 5th August 2022. Just a month before Malat the TED notification. You could have
As OBC.
as OBC. Malat, he could have applied much before. OBC certificate. Malat, he applied for OBC certificate on 5th August 2022.
Applied for OBC certificate.
For OBC certificate on 5th August 2022. Malat, on 29th September 2022, when notification was published, he applied in the TED as general category candidate.
Because he had no option.
Malat, at page 38 of the stay application. Then TED was held, Malat, 11th December 2022. Malat, he got the certificate 9th February 2023. 11th December 2022.
What is that? TET result.
TED Malat held 2022.
11th of July 2020. In the order impugned.
Notification was published on 11.
When did he
Malat, this is Malat.
did he ultimately get the OBC certificate?
Malat, ultimately he got the certificate Malat 9th February 2023.
After the TET.
After the TET was held. Malat, your lordship kindly consider Malat this fact on the point Malat this issue Malat was Malat Malat came up before this honorable court Malat the coordinate bench Malat passed the order. Malat just pat on the point. As your lordship also Malat the similar issue your lordship also held Malat just before vacation.
Candidates shall be there on the date fixed on the notification. On the
Yes.
date. Huh? Notification on 29th September.
29th
He
September,
applied in August, 5th August, September.
5th August, September, only
Just-
5th August, September.
yes,
My lord, he could have, my lord, the applied for much prior to that.
And declared himself as a jail.
He could not.
Tomorrow
My lord, I have cited the, my lord, the judgment is, my lord, the I have the better case today before your lordship.
So what is the urgency now? What is the
My lord,
problem?
urgency is that, my lord, on the basis of this order, my lord, he filed another lead petition, my lord, praying for, my lord, to participate in the new, my lord, recruitment process, my lord, is going on. 2025 recruitment process.
What is the wrong in that? Now he wants to participate as OBC candidate.
As OBC, but he has not passed the TET
Why?
2022. Unless he gets the, my lord, the benefit of OBC 5% relaxation, he could not pass TET 2022.
When is the examination?
But the interview is going on.
Interview is going on.
Well,
So we take it up on next Monday. What is the problem? Hard evidence of service coma as filed be kept on record. Mr. Visa.
But I am appearing for the state in this matter, my lord.
Appearing in the SLST.
Yes.
My lord, in item number 6, my lord, I am appearing for the state, my lord. On the last occasion, I have, my lord, filed the affidavit in opposition, my lord. So on the last occasion, they took time for the reply, my lord, but
State, you are for the state.
state, my lord.
How can you deny the benefit? It is res integra. It has already been decided.
My lord, it has been, my lord, but my lord, since my lord, my lord.
It has been decided. Issue is no longer resi. Obijit Vaidya Shefali. Widow will be entitled.
My lord. But my lord, widow has also died, my lord. That's why they have submitted, my lord, they have filed a substitution application.
Oh.
That is, and now, my lord, in the morning, my lord, the advocate on record, my lord, who was appearing for the appellant, my lord, she told that she has given NOC in the matter, my lord.
Where is the substitution application?
My lord, substitution application they have filed, my lord, as I remember, my lord.
So is there anyone in the family to receive family pension?
No, my lord. As I have filed, as I have stated in the affidavit in opposition, my lord,
Wants to be
my lord,
substituted?
no claim for family pension was,
Who wants to be substituted?
my lord, substituted, my lord. The
Mongola Bhattacharya was the
Wife
wife
of
of
the
the
deceased employee.
deceased employee.
Acha, now who wants to be substituted? Diprojit Bhattacharya is his son,
My lord.
and Kakuli Bhattacharya, wife of Mahadev Bhattacharya.
Ma-
Oh, that means Mahadev Bhattacharya was the son of.
My lord, there is too much confusion in this, my lord. That's why I asked for, we asked for the, my lord, documents from the, my lord, appellant, but they have not given any document regarding.
Diprojit Bhattacharya হচ্ছে ইয়ে বোধহয় নাতি।
মঙ্গলার ছেলে।
হ্যাঁ, না মঙ্গলার ছেলে হবে কি? Diprojit Bhattacharya son of Mahadev Bhattacharya. Kakuli Bhattacharya son of Mahadev Bhattacharya, wife of Mahadev Bhattacharya.
কাকুলি বাচ্চা।
Who filed? Who was Mongola?
Mongola is the
What is the name of the deceased? Jogeshwar Bhattacharya.
Jogeshwar Bhattacharya, the
Was the
deceased
employee.
deceased employee.
His wife was Mongola.
Mongola
Now
Bhattacharya
Mongola died.
died.
Now who is Diprojit, Mahadev, and
My lord,
Kakuli?
my lord, in respect of paragraph 3, my lord, they has made a contradictory statement, my lord, regarding the legal heir. In one place, she claims to have two heirs, my lord, namely Diprojit Bhattacharya and Kakuli Bhattacharya. While in the writ petition, my lord, she stated her husband died, leaving her as widow and two sons. That is the whole problem, my lord.
Oh,
no one appears on behalf of the
Tieback to appear on behalf of the applicant.
My lord, there is a direction to
Well, I'm
filing
for
in
the point number
opposition.
7.
opposition to the
State respondent, opposition. Or stay application.
Huh?
Stay application. Reply to. না ওটা সার্ভিস মনে হয় রিপ্লাইটা কোথায় গেল এই তো ছিল নিচে নিচে এই যে এই যে ওটার নিচে না না
May I be permitted to file my reply?
Yes, sir.
My lord, may take up the impugned order that is appended to my stay application, that is at page 67, annexure D. May I just place that first? The writ petitioner claims to be appointed in the post of night guard in Mongolkote AKM High School, District Bardwan on 1st January 2002 and has been drawing the consolidated amount of rupees 1500 per month from the fund of the school authority. Writ petitioner prays for regularization stroke absorption in the post of non-teaching staff in the school where he is discharging his duty as a night guard. In pursuit of obtaining order of absorption, previously a writ petition was filed by being such and such, and the same was disposed of by a coordinate bench with a order dated 5th October 2016, directing the District Inspector of Schools, Bardwan, to consider the case of the writ petitioner for regularization upon disposing of the representation made by him in this regard. Pursuant to such order, dated 5th October 2016, the concerned District Inspector of Schools passed a detailed order as contained in memo number such and such, dated 10th March 2017, whereby claim of the writ petitioner for regularization was turned down. Memo dated 10th March 2017, issued by the concerned District Inspector of Schools, is under challenge in the writ petition. This court has heard Mr. Such and Such representing the writ petitioner and also perused the impugned decision of the concerned District Inspector of School, which is the subject matter of challenge in the writ petition. This court has specifically asked the petitioner whether any formal appointment letter was issued by the school authority upon compliance of necessary recruitment rules prevalent at the material point of time while appointing the petitioner in such post of non-teaching staff, and whether appointment was against any sanctioned vacancy. This court does not find any satisfactory answer from the learned advocate representing the writ petitioner. Upon hearing the writ petitioner and considering the decision of the concerned District Inspector of Schools, it appears that the writ petitioner was not appointed following the necessary recruitment rules against sanctioned vacancy. In view of this, the writ petitioner does not have any enforceable right which can be protected upon issuance of mandamus. In this regard, judgment of the apex court in case of Uma Devi is relied upon. Accordingly, writ petition being such and such is dismissed. However, there shall. So, Lordship, this is the impugned order which is under challenge before your Lordship, whereby a memo issued by the District Inspector of School following the procedure laid down in Uma Devi, Lordship, that is under challenge in the writ petition. If Lordship kindly turns to now annexure S1, that is at page 62. This is the impugned order. That is also appended to my application. Page 62.
No,
62.
Order of the DI.
Order of the DI.
Here it is 52. Oh,
so it is again. It is again appearing at 62. It is annexed separately.
Yes.
Lordship, I am skipping over the first paragraph. From the second paragraph, I am placing. During hearing, learned advocate sought for a liberty to file a written statement and petitioner submitted the same on such and such date. According to that written statement, A, petitioner joined in service as a night guard in such and such school on 1st January 2002, which is evident from the certificate issued on 16/12/2014 by the headmaster.
That is a certificate, not a letter of appointment.
Lordship, I shall. Kindly bears with me. Lordship, now I shall place the third point. There is no post sanctioned as night guard. Fourth point, regularization of the appointment is only possible when it is within the power and province of the authority, if that had been done in compliance with the procedure and in the manner which it is related to the route of such appointment. If appointment is made by flouting the rules or if it is in violation of the provisions of the Constitution, such appointment is illegal and such appointment cannot be regularized or approved.
When did the commission provision for non-teaching staff came?
1997.
Huh?
1997.
97
Nine.
is Commission Act.
Commission Act. 2005. 2005.
2005 was
Five.
Control of expenditure.
Again, non-teaching.
2005 or 7?
2005.
5.
Teaching staff was
Non-teaching.
2005. It was the when the bid for. That you have no case.
Lordship, may I?
2005.
Because I shall only place two judgments. because
2005. Sir.
The facts of the case are more or less clear to my lords that my appointment,
My lord, may I?
my appointment has been classified as illegal. Lordship,
Okay,
thereafter
we
the
talk
authority
about
has relied upon the judgment of Uma Devi. Lordship, I shall only trouble your lordship with two judgments which I shall try to impress upon your lordship that I have an arguable case. Lordship, one is Nihal Singh versus
Equal pay for equal work. That is police service.
that is police service. Lordship, I would have placed reliance upon paragraph numbers 32 and
Illegal and
You
illegal.
just saw there is a post for night guard in a secondary school.
lordship, post of a night guard, lordship, if
Again, sanction post.
against sanction.
Even is regularization, direction of regularization is given against a post. So you show there is a sanction post.
Lordship,
Where you will be directed to be regularized? In a post.
Lordship, may kindly take up Annexure B, Lordship, that is page 15 of my Lord's brief. This is a letter to the DI Bardhaman. This is from the headmaster of the school.
You
Page 15, Annexure B of the application.
50.
15.
Are you still getting 1,500?
1,500.
It has now increased to around 4,000 rupees.
Enjoy that, sir.
But may I-
With your petition, you will lose that also.
Lord, the only point that I beseech your lordships to consider that I was appointed in 2002. May I just place this and then I shall place my submission. This is addressed to the District Inspector Bardhaman. With due honor, I would like to inform you that Munshi Moshejul Haq, that is the appellants before your lordship, has been working in this institution as a temporary Group D staff since 2002. There is only one permanent Group D staff and thereby I am facing a lot of difficulties to run this institution smoothly. In this state, I fervently appeal that you will kindly do the necessary arrangement to appoint him as a permanent staff and oblige thereby. If you do the same at your earliest convenience, I shall be highly obliged and grateful to you.
Certificate was issued after your first deputy.
Yes. This was issued after.
Just 2 months prior to the first deputy. First deputy was disposed of on 5th of October.
Yes. This is just prior to that. Because lordship, from the letter of the headmaster lordship,
It was 2005 scheme. Your continuance from 2002 was absolutely at the mercy of the school authority. Now there was no sanction post. Now sanction post after 2005 is to be filled up in terms of the rules.
Lordship,
How can we help you, sir? You want to argue any other point, you argue.
no, I have indicated to your lordship, I do not want to waste judicial time. I have indicated that those are two judgments. One, I would have placed Nihal Singh. Because lordship knows Nihal Singh paragraph 32 judge.
Where is your certificate of 16th of December 2014? It is referred to in the order passed by the DI. Petitioner joined service as night guard on 1st January 2002.
Yes.
Evident from certificate of 16 December 2000.
Which is, it is perhaps not annexed to the
Admitted.
এটা তুই বলবি
এখন lack of staff এর জন্য
that is not annexed to the petition.
exams এর টাইমে
2005 402 দাস কি করছে 2007 নাকি
একটা খালি স্যাংশন রয়েছে ওদের গ্রুপটি
What we want to show us in Nihal Singh.
2005
Nihal Singh, before Lordship takes up Nihal Singh, Lordship kindly takes the trouble of coming to page 64 once of my application.
আমার 64 নেই ভাই আমার 63 করে 65 আমি তোমার কাছে
This is an order passed by the Director of School Education of 2010.
সিলেকশন প্রসিডিউর
ওটা ভুল বের করেছে
সিলেকশন এই যে 2005
My lord, there were
রিক্রুটমেন্ট অন নন টিচিং স্টাফ
ওটা অ্যামেন্ডমেন্ট
ওটা অ্যামেন্ডমেন্ট হ্যাঁ
এক্সারসাইজ অফ supersession of Indian
amendment 2009 actually 2005
yes page 64.
Lordship, this is an order passed by the District Director of School Education. This is with regard to the school where I have rendered service. Lordship, in pursuance of GO dated 8/6/2007, the School Education Department, Government of West Bengal, Mongolkote AKM High School, District Bardhaman is hereby permitted to fill up vacancies from total sanctioned strength of 2 posts of clerk and 4 posts of Group D, including 2 lab assistants. So, Lordship, as per the
There was a vacancy.
Lordship, there was a vacancy. Lordship, even in 2016, the principal writes to the district inspector that
If this is to be given effect, then also you do not get because that selection has come to the terms of the rules.
next page my lord next page
yes,
So the post was filled up. This was of 18th of April 2018.
18
Eh?
2018
2018.
my lord nature post which selected group D peon
And when did you pass the order? DI order was page 64. DI order is dated
17 10th March 17 after that school service commission has recommended
I also did not know that there was
because Lordship, if my lord kindly takes note, there were 2 posts. One has been filled up. Lordship, there subject to correction, Lordship, there remains another post which is vacant.
your prayer. Your prayer is not that you condone my marriage and allow me to participate. Moreover, that is not there in the rules. How can we help you, sir? মামলা নিয়ে এসো আর কি করে। Bring up the
জাগ্রোটা প্লেস
case.
করে জাগ্রোটা প্লেস করে তারপরে তো তুমি জাগ্রো প্লেস করবে
হ্যাঁ, জাগ্রতার এই নিহাল সিং
You want Jaggo and ওই দুটো জাজমেন্ট দেখো।
ওই নিহাল সিং এন্ড জাগ্রো
আরেকটা আছে 25
Paragraph you are referring.
paragraph 32 and 33, Lordship. That is at page 78 on the left hand corner top, Lordship. Coming to the other aspect of the matter pointed out by the High Court, that in absence of sanction post, the state cannot be compelled to absorb persons like appellant into the service of the state. We can only say that posts are to be created by the state depending upon the need to employ people, having regard to various functions the state undertakes to discharge. Every sovereign government has within its own jurisdiction right and power to create whatever public offices it may regard as necessary to its proper functioning and its own internal administration. It is no doubt that the assessment of the need to employ a certain number of people for discharging a particular responsibility of the state under constitution is always with the executive government of the day, subject to overall control of the legislature. That does not mean that any examination by a constitutional court regarding the assessment of the regarding the accuracy of the assessment of the need is barred. Thereafter, Lordship, paragraph 35.
Yes.
Therefore, it is clear that existence of the need for creation of posts is a relevant factor with reference to which the executive government is required to take rational decision based on relevant consideration. In our opinion, when the facts such as the ones obtaining in the instant case demonstrate that there is need for creation of posts, the failure of the executive government to apply its mind and take a decision to create posts or stop extracting work from persons such as the appellants herein for decades together itself would be arbitrary action on part of the state. Lordship, these are the three paragraphs from Nihal Singh that I place reliance on.
35, para 30.
32, 33, 35.
আমার একটা মার্ক করা হচ্ছে এই দুটো দিয়ে দে যাচ্ছে এরপরে আবার আরেকটা এসছে 25-এ বিক্রমনাথেরই আরেকটা শ্রীপাল দেখানোর দরকার নেই
Lordship, with regard to Jaggo, my lords know that this was with regard to irregular appointment. I shall just indicate paragraph 7, Lordship, lays down the facts of the case.
Sir, we are coming back after 5 minutes.
ট্যাবটা দিতে হবে তোমার।
Paragraph 7, Lordship, lays down the facts.
এইটটা দে।
Lordship, paragraph 8,
9.
Lordship, here the arguments that were placed on behalf of the appellant that has been spelled out.
Arrow.
Paragraph 13, Lordship, I shall place 13, 14. May I place paragraph 13 once? The claim by the respondent that these were not regular posts lacks merit, as the nature of work performed by the appellants was perennial and fundamental to functioning of the offices. The recurring nature of these duties necessitate their classification as regular post, irrespective of how their initial engagements were labeled. It is also noteworthy that subsequent outsourcing of the same task to private agencies by appellant after the appellant's termination demonstrates the inherent need for this service. This act of outsourcing, which effectively replaced one set of workers with another, further underscores that the work in question was neither temporary nor occasional. The Lordship thereafter I shall place paragraph 16, if my lords may kindly turn. The appellant's consistent performance over their long tenures further solidifies their claim for regularization. At no point during their engagement did the respondents raise any issues regarding their competence or performance. On the contrary, their services were extended repeatedly over the years, and their remuneration, though minimal, was incrementally increased, which was an implicit acknowledgement of their satisfactory performance. The respondents' belated plea of alleged unsatisfactory service appears to be an afterthought and lacks credibility, Lordship. Thereafter, I shall come to paragraph 20. It is well established that the decision in Uma Devi Supra does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees have served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In the recent judgment of this court in Vinod Kumar versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary, but has performed the same duties as performed by regular employees over a considerable period and in capacity of regular employee. The relevant paragraphs of the judgment are reproduced below. Lordship, I shall not trouble your Lordship. Paragraph 21. The High Court placed undue emphasis on initial label of the appellant's engagement and outsourcing decision taken after their dismissal. Court must look beyond the surface level and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointment. This is paragraph 21. At the bottom. In that light, refusing regularization simply because their original terms did not explicitly state so, or because an outsourcing policy was belatedly introduced, would be contrary to principles of fairness and equity. The pervasive misuse of temporary employment contracts, as exemplified in this case, reflects on a broader systematic issue that adversely affects workers' rights and job security. In private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear even greater responsibility to avoid such exploitative employment practices. When public sector entitles engagement in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government operations. Lordship, and last is paragraph 26 and 27.
Yes.
While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. The judgment aimed to distinguish between illegal and irregular appointment. It categorically held that employees in irregular appointment who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where appointments are not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Uma Devi to argue that no vested right of regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. The selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over the decades. Lordship, thereafter, the Honorable Court goes on to allow the appeals. And Lordship, my learned friend has assisted me with one more judgment. I shall only indicate it, my lords know. It is the judgment rendered in Dharam Singh. Paragraphs 11. It relied upon Jaggo, and Lordship further clarified that.
What is your answer to that?
My lord,
What is your answer to Jaggo and Dharampan?
my lord, it is indicated in the judgment, both of the judgment, that if there is an irregularity, that can be regularized. But if it is an illegality, that cannot be regularized. That is Umadi. My lord, what happened in this case, my lord, if any advertisement has been made, post, my lord knows that a selection process is start with an advertisement and ends with an giving an appointment letter. Here in this case, no post sanctioning memo is there, no advertisement is made.
You have filed an opposition admitting his service.
Well, admission is,
You have admitted that he is serving from 2002.
yes,
So it comes under the parameters of Jaggo.
Jaggo, but no procedure has been followed. And in the meantime, your lordship knows that 2005 and 2000 amendment is 2009 Act came into force. So all the appointment, now the state authority do not have that jurisdiction or authority to appoint.
Such rule at that time.
Yes, my lord. At the material point of time, there is no rule. But
it was the discretion of the managing committee.
My lord.
Committee appointed. What is the illegal?
My lord, then my lord, the managing committee never forwarded his papers to the DI authority unless there is a writ petition which gives a direction upon the DI.
permission for forwarding. If they do not forward, why he should suffer?
My lord, that is the contingency fund, my lord. He now is also
So there is necessity. So necessity cannot be ruled out.
that is
So when there is no necessity, then why you are saying that it is an illegal appointment?
illegal appointment.
Engagement term, illegality will be the parameter of inducting somebody prohibited or choosing a particular person from the village. And
My lord, kindly, if my lord, there is not a single document except my lord, there is a certificate, not a single document which gives my lord there is a letter of appointment. No appointment, even no appointment letter is there. Nothing is there. Well, at the material point, there is a provisions of sending the name from the employment exchange. That has also not been done.
present appeal has been preferred. As provision that there has to be a sanction post for doing it.
Yes, my lord. The post-sanctioning memo is always required.
There is a 2002, that is the inability and indolence of your DI. DI did not, if the school would have approached at the right time, DI would have issued prior permission.
School never asked for any prior permission. It was not sought it.
Any selection procedure?
Any selection process, any advertisement, any names from the employment exchange. And I know it goes against me.
Number 1, 2, 3 of me. Primarily praying for issuance of necessary direction. অর্ডারটা সই করলে পাঠিয়ে আচ্ছা
I beg to appear for the appellant, my lord.
yes
Last occasion, Lordship directed Mr. Mukherjee appearing for the state, my lord, to file an affidavit in opposition for Section 5 application, my lord.
Lordship,
424 days delay, my lord.
Lordship, I'm appearing for the state led by Mr. Tapan Kumar Mukherjee. Lordship, we need 2 weeks extension of time for 2 weeks, Lordship.
Regularization.
No, my lord, the selection process of Group D staff before coming into effect of 2010 rules, my lord. School Service Commission Act is not applicable here. The
2010 or 2009.
2009, I'm sorry, 2009. The panel was prepared, my lord. The appellant stood second. The first appellant candidate, my lord, he appeared before the selection committee pursuant to direction of this honorable court, and that writ petition ultimately dismissed. So, my lord, his candidature gone. Now, the second appellant candidate, being the appellant hearing, he is entitled for appointment. That was not given. DI passed an order, my lord, cancelling the entire panel, directing the authority, my lord, to recast the panel, giving the third impanel candidate as the first, cancelling candidature of both 1 and 2. But I was 2. Because, my lord,
Where is your service upon the private respondents? Sonoth and Tapos? Have you served upon them?
it's not the affidavit of service last occasion I have submitted.
Take up. Now what happened? Fresh selection process initiated?
No, nothing.
The selection process of Group D.
Group D.
Group D staff.
Group D staff.
School.
In a school. Now, kindly see the impugned order of the DI, page 45 of the stay application. The relevant portion, page 46.
There was no advertisement.
Since there was no advertisement, we approached before the Honorable Court. Honorable Court passed an order directing the authority.
So that is bad in terms of the judgment Rajvamshi. Justice Pratap Rai judgment.
My lord are good.
This itself is Rajvamshi judgment. Rajvamshi judgment is against you.
One thing may I submit, my lord. When I approached before the Honorable Court, the Honorable Court has not directed the authority to
not to call the sponsored candidates.
No. Honorable Court.
Direction was only on the basis of the direction issued by the court to
participate. I participated. So far as the participation is concerned, my lord, that cannot be questioned.
Holding the interview itself was bad, no? That is, court proceeded on the basis that there was no open advertisement.
There is no open advertisement.
How can you overcome that?
DI has proceeded on different ground.
How do you overcome paragraph 40, paragraph 20 of the judgment?
Yes, ma'am. Paragraph 20. Therefore, the choice of selection of candidates was restricted only to the candidates sponsored through the employment exchange and those permitted to appear in the interview pursuant to the orders of the Honorable Court. No advertisement for filling up the vacant post was published by the madrasa. Many eligible candidates may have been deprived of the opportunity to be considered. But my respectful submission is that, my lord, the selection process was thus initiated and panel was prepared in violation of the law declared in KBN Vishweswar Rao. My lord, my respectful submission before is that, my lord.
ওটা নিয়ে এসো না। You show us that the Rajbongshi does not have after this Ohed Ali was there. Single judge judgment delivered by Justice, our ex-Chief Justice Jyotirmoy Bhattacharya.
Ohed Ali.
Against that, we went up to Supreme Court, not interfered. Show us something so that we can help.
Now, today, the first hurdle. No, I have. I will place.
The delay and dismiss the appeal.
No, I will. Kindly condone the delay, my lord. Next day, my lord.
We will condone the delay if you show us that there is ground on merits of the matter.
My lord.
Yes, tell us when can you come.
Next Monday, my lord.
Next Monday.
Yes.
File your opposition in the meantime.
Lordship.
Heard Mr. Hossain, learned advocate appearing for the appellant.
Devendra Pal.
Your other side is here.
Mr. Dotto is appearing.
Only that document was directed to produced.
So we ask Mr. Dotto at 2 p.m.
2 p.m.
I'm defending that section 5 application. Your Lordship, this is that matter. Your Lordship wanted a copy of a memo dated 28th February. We have just received that copy. Your Lordship directed us to furnish a copy of that order or memo. Last order, Your Lordship, kindly see the last one.
See that. You said that you will bring that.
Yes. My Lord, I have got it. May I hand up to Your Lordship, my Lord? ওদেরকে একটা কপি দিতে হবে তো। Yes. So this letter was written this 28th February 2025. This we have stated in paragraph 3 of the section 5 application. So Your Lordship wanted to see that letter and I also wanted to produce it. So that's why there was a direction to produce this memo. This is from the DI, North River Parganas, dated 28th of February 2025. Subject prayer for obtaining a certified copy of the order dated 16th of January 25, passed by Honorable Justice Rai Chattopadhyay in such and such. I have to invite a reference to the court case cited above and to request you to kindly take such a step as may be deemed fit and proper for obtaining a certified copy of the above mentioned order with the request to furnish the same to this office for taking necessary action at this end. So, my Lord, because this document was not annexed to the application, Your Lordship, my Lord, the existence of the document was to some extent doubted.
Total delay of how many days?
184 days. 184 days. It's not that, my Lord, that Justice Pardiwala's judgment 11 years. It is not that. So, my Lord, the background in the prospectus of the Justice Pardiwala's judgment is entirely different here. There is civil decree was not being executed for 11 years. That's why those remarks, those observations and all. So, my Lord, the precedence doctrine may not be applicable in this case. I'll be citing the Narmada Bajao Committee Narmada Bajao judgment 2011.
On the date of knowledge, the date of knowledge বলছে 31st January 2025 এইখান থেকে
communicated to you on 31st January.
Lordship, I've said that, my lord.
Yes, para 1.
Lordship.
You applied on 10th of February. That is. Copy of the order was received
My lord, the
10th of February.
10th of February 25. My lord may recall that this matter came up after 15 years. 15 বছর বাদে, না? After about 15 years. So, my lord, no notice was there to the government of West Bengal, my lord. So that, my lord, it came up on a day and it was disposed on the same day. My lord, I cannot say, my lord, that a notice ought to have been given such an old matter coming up. There have been many changes in the meanwhile.
Anything was recorded in the order as regards notice?
My lord, the lordship, no. Lordship kindly sees, only thing is recorded is, lordship kindly sees, my lord, the lordship, my lord, the recorded that it is recorded in the order. The paragraph 28 of the impugned order, judgment and order. But which says, since no affidavit is invited, paragraph 28, page 64 of the stay petition of the impugned order, it is written, since no affidavit is invited, the allegations contained in the petition are deemed to have been denied by the respondents, including the private respondents. Well, direction ছিল তো। এটা direction ছিল। একটু মনে রাখো না। ওটা থাকো না আগে। Lord,
How that para is relevant, Mr. God? The actions were passed, you were defeated. Now the affidavit invited allegations contained that if the allegations are denied, that case that ought to have been
no, my lord, what I want is, affidavit was invited in 2013.
Affidavit was invited?
Yes. Last occasion, my lord, I think, my lord, hey, must be invite affidavit ছিল না, এই বল না। হ্যাঁ, affidavit direction ছিল। Yes, direction. It was there, my lord, the direction for affidavit was there.
When was the direction?
That was in 2013. In 2013, when the writ petition was admitted, or yes, 2013 writ petition.
Then you did not use any opposition.
No. Now, my lord, no affidavit was filed and nobody appeared on 16th of January 25, because after 2013, in January 2025, the matter is taken up for final hearing. But my lord, this, with respect, my lord, I say this recording of that, that since my affidavit is invited, this is, my lord, not, my lord, on record. Affidavit was invited.
136.
But my affidavit was filed. That's a different issue altogether. চলে না, বাতও নেই থেকে। I've said nothing, well, I'm candid about it, well, I've said nothing. But well, it is recorded in paragraph 14 of the impugned judgment. None appears for the state respondents, and in paragraph 15, in view of the facts and of this case, the same is taken up for adjudication in absence of the state respondent.
Yes, which judgment are you? So you apply your DI approach the legal remembrance on 28th of February.
Yes. And Malad,
The legal remembrance are granted leave to file appeal on 4th July.
Lordship.
4th July.
Lordship.
In the meantime, your DPPC by a letter dated 27th February asks the DI to furnish
revised pension papers.
So you had said that Mintu Goswami was the advocate. Last occasion you said Mintu Goswami was engaged.
Yes.
That is also not reflected here. That
It is,
Mr. Mintu Goswami expired. What
that is
happened?
not there. That is not.
This should be an appropriate Mr. Dotto there has
So, Lordship, I understand, Mala, there is some lack of, that's why I wanted, but since affidavits have been exchanged, Mala, I wanted to file a supplementary affidavit on record. That means Mintu Goswami, who was the advocate in this matter, he died in the meanwhile. So when the matter was taken up, no notice was given to the state respondents, or Mala, the
how can we allow you to
no,
fill up the lacuna now?
That's my predicament. That's my predicament, and that's my disadvantage, I should say. Now, because
your contention is we the 184 days, there was no deliberate
lackness or negligence
back on our part. We got the communication, we approached the LR, and the LR, on behalf of LR,
there was some delay in filing papers, and I have got the yes.
About 4 months, and after the LR's permission, you applied for certified copy.
Yes, about 2 months. Then there was as such no delay.
4th of July 25, approval was
accorded. Yes.
22nd July, engagement letter.
Yes. Then memo was filed on 18th of August. Each day's delay.
Your judgment, your delay.
The judgment, my lord, the judgment go down. Internal judgment. খুলে দিচ্ছ খুলে দাও এটা খুলে দাও
তোমার judgment আছে তো
the judgment, daily development of the judgment, Justice Chatterjee relied on in that the sitting with Justice Tandon. Only, my lord, I'll place. This is, my lord, 2024-7 SCC 433. My lord, may paragraph 25. May I place my lord para 25? As is clear from a plain reading of Section 5 of the Act, Limitation Act, there are exceptions to this general rule.
Paragraph 25.
25, page 476 of that judgment. Justice Chatterjee knows this because this was relied on. Then, my lord, as is clear from a plain reading of Section 5 of the Limitation Act, there are exceptions to this general rule. So I'll be harping on these exceptions. Now, my lord, the statute allows for admitting an action provided sufficient cause is shown. This vests courts with the discretion to extend the period of limitation if the applicant can show that he had sufficient cause for not preferring an appeal or application within the prescribed period. Section 5 requires analysis of two ingredients. First, an examination of whether sufficient cause has been made out, and second, whether such cause has been shown for not filing the appeal application within the prescribed period. My lord, then my lord, lordship takes, my lord, I just only place only relevant portion. Paragraph 29. Paragraph 29. In addition to sufficient cause, Section 5 also requires that such cause must be shown within the prescribed period. To satisfy the latter condition, the applicant must show sufficient cause for not filing the appeal application on the last day of the prescribed period and explain the delay made thereafter. Causes arising after the culmination of the limitation period, despite being sufficient in substance, would not suffice for condition given in second prong of Section 5 of the Limitation Act. However, well, this is the exception part. However, applicant shall not be required to prove each day's delay till the date of filing of such appeal application. I judgment this judgment, Justice, this is a three judgment to which Justice Dipankar Datta is also a party. This is where Justice Surjakant, as the Lordship, then Justice Dipankar Datta, and then Justice Ujjwal Bhuya, three judgment. Now, my lord, this now relying on, my lord, judgment delivered by 2023.
This only you, no other paragraph you are wanting to show.
I just only this
paragraph 25 and 29.
Yes. Now, my lord, I'm sorry. I wanted to cite another paragraph. I missed it, my lord. I'm extremely sorry, my lord. 28, I also, my lord, I'm also relying on. 25 and 28 of this judgment. 25 I have placed and paragraph 28. The court must also desist from throwing the baby out of the bathwater. A justice-oriented approach must be prioritized over technicalities. As one motivation underlying such rules is to prevent parties from using dilatory tactics or abusing the judicial process. Pragmatism over pedanticism is therefore sometimes necessary, despite it appearing liberal or magnanimous. The expression sufficient cause should be given liberal construction so as to advance substantial justice. I am on the last sentence. I am on the last sentence of paragraph 28.
Why do you say substantial justice is being interfered with here?
Here, my lord, the lordship kindly why this liberal construction to be advanced to substantial justice, my lord? Here, my lord, if your lordship goes to the merit of the matter, my lord, he was not entitled to the period. He resigned from the service. That period has been that is to be calculated for giving him benefits. He was not in service. So this, my lord, part is very important. If your lordship goes to the merit of the matter, I'm sure I'll succeed. I'll be able to satisfy your lordship. So, my lord, here, that's why, my lord, I'm emphasizing on the expression, sufficient cause should be given liberal construction so as to advance substantial justice. This is a three-judgment decision. Here, my lord, the Justice Dotto is the party, and Justice Dotto's judgment in the case of, this is reported, it was reported.
Shivraj Singh. Shivraj Singh.
Shivraj Singh. My lord,
Excuse and explanation. Excuse and explanation.
this is the, my lord, this is judgment. But the references, but I have not mentioned here. Yes. This is actually, my lord, 2023 reported 2000 লেখা হয়নি এদের উপরে এবার লিখে দেওয়া উচিত ছিল but this is 2023 10 SCC 531. I'm relying on paragraph 31, 32 and 37. Paragraph 31, my lord, internal page 17. Lord, if I may read for your lordship, my lord. The order under challenge in this appeal is dated 21st December 2011. It was rendered at a point of time when the decisions in Musammat Karzi, Ramdev Gowda, Supra Chandimani, so and so were holding the field. It is not the said decisions. It is not that the said decisions do not hold the field now, having been overruled by any subsequent decision. Although there have been some decisions in the recent past, state of MP versus
Verulal.
is one of the decisions apart from University of Delhi, Supra, which have not accepted governmental lethargy, tardiness, and indolence in presenting appeals within time as sufficient cause for continuation of delay. Yet, the exercise of discretion by the High Court has to be tested on the anvil of the liberal and justice-oriented approach expounded in the aforesaid decisions, which have been referred to above. Now, my lord, your lords will find, my lord, that this, my lord, the Justice Dotto's view is in tune with the view of three judgments, which is also there. It is in tune with that. Then we find that the High Court in the present case assigned the following reasons in support of the order. The law of limitation was founded on public policy, and that some lapse on the part of a litigant by itself would not be sufficient to deny condonation of delay, as the same could cause miscarriage of justice. The expression sufficient cause is elastic enough for courts to do substantial justice. Further, when substantial justice and technical considerations are pitted against one another, the former would prevail. But I am relying on this, I am emphasizing on this. It is upon the courts to consider the sufficiency of cause shown for the delay, and the length of delay is not always decisive while exercising discretion in such matters if the delay is properly explained. Now, my lord, I am hit by this, but if the delay is properly explained. My lord, in my case, it is not, my lord, it is my fault, my lord, I should say. It should have been explicit, more explicit. But, my lord, there is some, my lord, latches. But, my lord, lordship, kindly keep in mind that the expression, my lord, the expression sufficiently elastic enough for courts to substantial justice. So, lordship, to do substantial justice, lordship, kindly consider that aspect of the matter. It is upon the courts to consider the sufficiency of cause shown for the delay, and the length of delay is not always decisive while exercising discretion in such matters if the delay is further, the merits of a claim were also to be considered when deciding such applications for condition of delay. So, my lord, the merits of the claim were also to be considered.
Merits of the claim.
of a claim were also to be considered when deciding such applications for condition of delay, then the further
No, that Mr. Shivraj Singh was considered in Shivamma. What is the
Shivamma, I am coming. Shivamma, I just lost him. I mean,
and there is another judge of Madhya Pradesh. That judgment
after
I-
Shivamma, Shivamma
Bilal
possibly
of Madhya Pradesh.
Very well, 2020.
2020.
No, in the
Shivamma,
Shivamma judgment, has it? Have you come across this paragraph that court is stopped from considering the merits at the Section 5 stage, as it has been said here, that this court can do.
Yes.
That
They are also
merits of a claim can be considered.
Yes, they are
Is
also.
there any?
I'll be coming. I'll be coming. I've got your lordship, my lord. Lordship, kindly let me place this paragraph hurriedly, my lord.
Mr. Dotto, there are two things. One is previous judgments were that if there is a delay, there is an issue of compensation also. You can impose cost upon the respondents and condemn them.
Lordship.
But it was being many matters, it was that this rider, that payment of compensation or payment of cost cannot be a ground taken for condonation of delay, subject to correction.
Yes,
And the
your lordship
second
is
is,
correct. Your lordship is correct.
and the second is that if there is a substantial point of law involved, still you cannot go into that. You have to restrict yourself in the discretion. You show us that these two proposition, if this proposition has been affirmed, then Mr. Dotto, it becomes difficult for us to condone.
I get your lordship, my lord. Now, my lord, lordship, I just, my lord, I'll come to that judgment of Shiva Mamala immediately, my lord. Lordship, my lord, I just, then, my lord, আমি এটা বাদ দিয়ে দিচ্ছি না ওইটা দেখি না এটা judgment of Shiva Mamala.
হ্যাঁ, স্টেট অফ এমপি ভার্সেস ভেরুলা। বলে দিচ্ছে 3 judges যে they have not accepted the
SCC online. And I've written it by hand. 2025 STC online, Supreme Court, 1969. It is the top color this is 2025 SCC online, Supreme Court, 1969.
Yes.
Para 119, 120, this Shivraj Singh was considered.
That's it. Lord, I need to place some more paragraphs, but before that, my lord, I just take your lordship to paragraph
is an ultimate বোঝা difficult.
Lord, Lordship, my lord, your lordship takes for pages 167 towards the last part. 167. And 168.
Yes.
Lord, I just place, my lord, this paragraph 260, and then my lord, I'll take your lordship to the conclusion part. From the above exposition of law, it is abundantly clear that the High Court has erroneously condoned a massive delay of 3,966 days delay. 3,966, that is about 11 years. On account of certain lapses at the administrative levels and of there being no follow-ups in the proceedings, along with finding certain merits in the case of the respondent number 1 against the maintainability of the suit of the appellant and that of the relief molded by the first appellate court. We have no hesitation in stating that such grounds are nowhere near to being sufficient cause. As per section 5, the High Court lost sight of the
Page 2,
fact.
para 260, page
Para
160.
260, page 167. It was the last part.
Yes.
I'll take your last to the other paragraphs previously, but I'll just the conclusion.
yes,
Last
yes.
kindly see.
I could lost sight of. Yes, continue.
Yes. We have no hesitation in stating that such grounds are nowhere near to being sufficient cause as per section 5. The High Court lost sight of the fact that the precedents and authorities it relied upon by it had delays of 2 digits. Plus, you can see, as there are 2 digits. In my case, it is 3 digits, 184 days. And there were 4 digits, 3,966 days. Or even that of single digit, more particularly the delay in those cases was supported by sufficient cause. The present case, however, stands on a different footing. I am allowed, Lordship, kindly, this is very important. Owing to such an enormous delay, there is an enormous delay in this case. Hence, we are not inclined to accept the condonation of the delay by the High Court. Then,
This was a writ proceeding or
No.
the main suit?
There was a civil suit, there was a decree.
I
There was a decree, yes. I think there was a, yes. Appellant was decree holder in execution case. And no, execution was held up for 11 years. Execution of a decree was held up for 11 years.
Appellant was the
Appellant was the decree holder. And that decree, execution of that decree was held up for 11 years. In that background, the Justice Partiwala has delivered this judgment in Shibama. So 11 years the execution decree could not be executed.
No, appellant was the
decree holder.
Decree holder.
and the execution of which was held up for 11 years. And this enormous delay was condoned by the High Court and rejected by the Honorable Supreme Court, and the judgment of Sevama came. So the factual background is very important. Now, my lord, this may I proceed, my lord?
Yes.
Then, my lord, this conclusion part, I just take your lordship, my lord, what is ultimately held. Ultimately, my lord, it was held that sufficient cause is that is there. That has not been disturbed, even by this judgment. My lord, I just space it. Only a few paragraphs. Thus, for the reasons aforesaid, the improved order of the High Court deserves to be set aside. Before we proceed to close this judgment, we deem it appropriate to make it abundantly clear that administrative lethargy and laxity can never stand as a sufficient ground for conclusion of delay. And we want to convey an emphatic message to all the high courts that delays shall not be condoned on frivolous and superficial grounds until, this is the exception carved out, until a proper case of sufficient cause is made out, wherein the state machinery is able to establish that it acted with bona fides and remained vigilant all throughout. Procedure is a handmaid to justice, as is famously said. But courts, and more particularly the constitutional courts, ought not to obviate the procedure for a litigating state agency, who also equally suffer the bars of limitation from pursuing litigations due to its own lackadaisical attitude. So, at part, private litigant or government litigant at part. Then, the high courts ought not to give a legitimizing effect to such callous attitude of state authorities or its instrumentalities, and should remain extra cautious if the party seeking condonation of delay is the state authority. They should not become surrogates for state laxity and lethargy. The constitutional courts ought to be cognizant of the apathy and pangs of a private litigant. Litigants cannot be placed in situations of perpetual litigations wherein the fruits of their decrees or favorable orders are frustrated at later stages. So, this is in the background of that 11 years enormous delay. We are at pains to reiterate this everlasting trend and put all the high courts to notice not to reopen matters with inordinate delay until sufficient cause exists, as by doing so, the courts only add insult to the injury, more particularly in appeals under section 100 of CPC, where its jurisdiction is already limited to questions of law. So it is in the background of section 100 of the CPC, this was done. So the civil court decree was not executed for 11 years, or the latches or not the part of the state authority. So this is, my lordship kindly sees, the emphasis is still there until a proper cases of sufficient case is made out, until sufficient cause exists. So, my lord, the lordship here, my lord, these exceptions have been carved out to protect the sufficient cause as provided in section 5 of the Act. There, my lord, here lordship, my lord, has to consider whether sufficient cause has been made out in this case or not. Now, my lord, certain facts ought to have been stated in the applications for continuation. I know, my lord. Namely, my lord, the erstwhile advocate died. Namely, secondly, the matter came up for hearing after 15 years, and on the same day it was disposed of. There is a wrong finding of the learned judge that the state was not invited. State was invited but not filed. So, my lord, and my lord, no notice was given to the state authorities. This, my lord, bundle of facts, lordship will kindly consider. So these have not been stated in, my lord, the section 5 application, but some of them have been stated, and my lord, these are all on record. If your lordship, my lord, if the record of 2013 petition is brought to court, it will appear from there was a direction. And my your lordship knows, everybody knows that Mintu Goswami is no more there. So, my lord, that there's my lord, a notice. If after notice nobody appeared, then the learned judge could proceed with the.
Yes.
my lord, the
ডিসক্রিপশনের
my lord, I
ফাইলটা
guess
আছে
I'll
কি
be
এখানে?
writing, my lord.
ডিসক্রিপশনের ফাইলটা কি আছে এখানে? হ্যাঁ।
Token আছে, this original record token
It is appearing.
Then the original requisition must be tagged with their content.
So it is not a threat. Compliance is not a threat of contempt. At that point of time, contempt was not filed.
No, we will hear you. No, we are wanting to ascertain that whether there was direction for affidavit, as you are saying.
Yes.
And what is the date of such direction for?
No, that was the.
That was in 2013.
No, বলে দিচ্ছি।
8 October 2013.
Oh, yes, 8 October 2013.
It was followed by.
তারপরে কি হলো?
Then no steps have been taken on behalf of the
After
state.
8th October, matter never appeared. After 8th October,
No, this matter appeared under the heading old matter.
after 8th October, Mr. Wadi, in between there
In
was.
between, maybe, my lord, there was.
I don't think so. Subject to correction, of course. I have not checked the records.
And taking the name of Mr. Mintu Goswami, he is not the alone lawyer. Mintu Goswami was there initially, but Taposh Mondal was also there in the state panel to show.
Anything else you want to tell us, Mr. Dotto? Or anything else you want to tell us? We can start Mr. Badi's.
Yes, my lord, only one thing, my lord, that so therefore, my lord, what I'm citing, well, just last kindly to 18 the key. So I'll cite, my lord, only one judgment of Narmada Bajaj. Your lordship knows the presidential value doctrine, whether applicable here, because the fact situation of all the cited judgments of Justice Pardibala, this judgment, and also, my lord, they are different. So therefore, my lord, your lordship, my lord, I'm relying on this judgment. There are other judgments, but I'm citing of this judgment 2011, volume 7, SCC 639. Your lordship knows this judgment, I know. Only one paragraph, paragraph 64. On the precedence doctrine.
তো 11 কি নামটা কি বল?
এটা হচ্ছে ওই নর্মদা বাঁচাও। এটা মধ্যপ্রদেশ ভার্সেস নর্মদা বাঁচাও আন্দোলন and another. Paragraph 64. Only this paragraph, my lord. This is very off. Paragraph 64. On the precedence doctrine, the court should not place reliance upon a judgment without discussing how the factual situation fits in with the fact situation of the decision on which reliance is placed. As it has been it has to be ascertained by any analyzing all the material facts and the issues involved in the case and argued on both sides. A judgment may not be followed in a given case if it has some distinguishing features. A little difference in facts or additional facts may make a lot of difference to the presidential value of a decision. A judgment of the court is not to be read as a statute, as it has to be remembered that judicial utterances have been made in setting of the facts of a particular case. One additional or different fact may make a world of difference between the conclusions in two cases. This is oft quoted in many judgments. One additional or different fact may make a world of difference. Disposal of the fact situations of the judgments in some.
No, fact situation may be different, but the state it is the state's laches. Fact situation which you are arguing that in a civil suit, second appeal, decree was not executed, etc., etc. But the issue is the negligence on the part of the state
authority. Yes, lordship. They have been treated at par.
So that negligence of state authority has been, you may at best advance this agreement that the facts and circumstances on the basis of which the negligence was construed may be different here. But his argument will be that what was the issue of decision? State's inaction. So in state's inaction, Mr. Dotto, unless you can, there you can say that it is a
lethargy in this case, in my case.
lethargy element is absent. Your argument may be so.
And
11 years, here it is 184 days.
184 days. 184 days. And Maladi, it is not that merit has been absolutely negated. Even in the judgment of Justice Pardiwala, it is not negated at all. If the sufficient, if discretion, loss of discretion is already still there, it has been protected even by the judgment of Justice Pardiwala.
Now, where is that merits can be gone into?
This
Honorable Justice Pardiwala's judgment.
That is Shibamma.
Which paragraph you said?
Lost gives me 1 minute.
Yes, yes.
Followed in paragraph 261, if your lordship takes paragraph 261, there are other paragraphs I can here lordship will find. I just read for your lordship once. Thus, for the reasons supported, the impugned order of the High Court deserves to be set aside. Before we proceed to close this judgment, we deem it appropriate to make it abundantly clear that administrative lethargy and laxity can never stand as a sufficient cause for concern of delay. And we want to convey an emphatic message so and so until a proper case. Lordship kindly, that's what I said, until a proper case of sufficient cause is made out. So, this is the exception part. Exception has been carved out until a proper case of sufficient. So, everything is subjected to this until a proper case of sufficient cause is made out. And, in previously in different pages and different paragraphs of this judgment, how this conclusion has been arrived at in Shibamma case of the Honorable Supreme Court. What you said? Oh, if I 122. Lordship, just a minute. I just. But the if your lordship, this 1 minute, if your lordship, if I may make your lordships to page 158 161. If your lordship, the page 160.
160.
Yes, page 160, paragraph 249. 49. The discussions prior to the conclusion, some of the discussions are relevant. Once the paragraph 240, once the state chooses to litigate, it must shoulder the same responsibilities and abide by the same limitations and bind every litigant. To permit the state to evade the consequences of delay on ostensible plea that the fault lay with individual officers would amount to diluting the rigors of limitation statutes and undermining their very object. Such an approach would not only privilege the state unjustly over private parties, but would also perpetuate a culture of indifference and irresponsibility within the administration. Then, that's the I have already placed the culmination of the ultimate conclusion of the judgment. Then, this paragraph, page 162.
Page 249. Shivamma.
Paragraph 252, page 162, if your lordship takes. Paragraph 252, even if the case put up by the respondent number 1 is to be accepted at its face value, the respondent number 1 could be said to have failed to assign any genuine sufficient cause to justify the delay from the date of receiving intimation about the order of the first appellate court passed on 15th April 2026 till the expiry of the limitation period, which was sometime in July 2006, because it was only in the correspondence dated 17th of October 2006 that the respondent number 1, while acknowledging the advice tendered by its advocate, reflected that it would prefer a second appeal. We have little to no hesitation in saying that on 17th October 2006, it was already too late in the day to take a decision or make any forms of mind. Nonetheless, the second appeal was only filed on 10th of February 2017 with a delay of almost 11 years. So, my lord, this inordinate delay and then my lord, my lord, some of these observations are against me, but even then, my lord, to assist your lordship, my lord, I am placing was my lord, my lord, the Honorable Supreme Court is harping on the enormous delay. In every paragraph, 254, lordship kindly sees paragraph 254, next page 163 and 255. We say so because if such observations of the High Court to condone delay in the interest of state machinery were allowed to be sustained by us, it would allow the state machineries a leeway to sympathetically orchestrate delays in the guise of laxity exhibited by their authorities. Given the majesty and colossality a state machinery would hold against a private litigant, it would be grossly unfair to a litigant who would be perpetually entangled in the clutches of litigation if enormous delays, like that of almost 11 years in the present case, are permitted to be condoned. This court has never turned a blind eye to the gradients of substantive justice. So, my lord, the entire judgment proceeds on the basis of inordinate delay of 11 years, which is absent in my case. So, my lord, the lordship kindly sees 255. Why this judgment has come? It hardly 255 I am reading. It hardly matters whether a litigant is a private party or a state when it comes to condoning the gross delay of more than 11 years. So, whether it is a private party or a state party, when there is a delay of more than 11 years. So, in that background, the private litigant and state litigant has been put at par. When there is a delay of about 11 years or so, then they are put at par. Not when 184 days and 11 days, 11 years. Small lordship, may I read for you? It hardly matters whether litigant is a private party or a state when it comes to condoning the gross delay of more than 11 years. So this is a distinguishing aspect of the matter. Both the private party and the state are at par. when it comes to condoning the gross delay of more than 11 years. Then, if the litigant chooses to approach the court long after the lapse of the time prescribed under the relevant provisions of law, then he cannot turn around and say that no prejudice could be caused to either side by the delay being condoned. This litigation between the parties, logically says the factual aspect is here. Between the parties started in 1989. We are in 2025. Almost 36 years have elapsed. However, the litigation started in 1989, it comes to an end in 2025. So, that resulted in more than 11 years delay, and the observations of the Honorable Court restricted when both at par. So, in my humble submission, you also when treating the par, you also kindly also consideration, treat them in the background of 184 days and 11 years.
Yes, we understood.
So these are my submissions.
Yes, Mr. Bari. There is a delay of 184 days. Yes. And it was ex parte.
Calculation was 250. However, the one that when the department calculated, anyhow, well, I'm not in the debate whether 184 or 250. The question is whether the explanation was sufficient or not. The 16th January, the order was passed. 31st January, they received the communication. From 31st till filing of the appeal, what steps they have taken. If it is 16th of January, when my lord, the server copy, your lordship is always giving liberty to file an appeal without the certified copy. Nothing was done. So, my lord, they have applied, they said, your lordships kindly have a look to their affidavit in reply. In para 2F, 5F, page 5.
To their reply.
Their reply. Page 5, your lordships kindly, page 5. The application for certified copy, page 5, top. The application for certified copy of the judgment and an order dated 16/1/2005 was made on 4/3/2025. Why? There is no explanation. Anyhow, the certified copy was made ready for delivery on 10th March. To show 10th March, the certified copy was available. Certified copy was ready for delivery. On 7th, appellant sent a proposal. The proposal always after certified copy, but before certified copy, on 7th, the appellant sent a proposal under memo number such and such to the Commissioner of School Education Government for preferring the appeal against the judgment order dated such and such. On 10th, the appellant issued a letter to the concerned school authority by memo number hold to matter until further order. On 24th, the appellant 3 issued a letter to the concerned school authority via memo number, a copy whereof was forwarded to the writ petitioner, but this has not been consciously disclosed in the writ petition in the said affidavit. Other memorandums have been annexed in the writ petition. Now, after observing official formalities, the preferring appeal against the aforesaid judgment order dated 16/11/2025, the learned legal members of West Bengal approved the filing appeal on 4/7/2025. Where is the explanation of the 4 months delay? In the month of March, 10th March, the certified copy was available. From 10th March to 4th July 2061, is there any explanation? The certified copy was given to that. They took time to that. The explanation was condonation, whether the appeal will file or not. The prayer was made. Nothing was else. Only they said that the learned legal, the order dated 16/1/2005 in WP, the learned legal members of West Bengal approved the filing of the appeal on 4/7/2005. If the certified copy was obtained on 10th March, and my lord, the approval was given, where is the explanation? Why the 3 months? State lethargy, sufficient cause of action. That is the categorical Supreme Court has, as one of the 2 coordinate division bench was also held. That the attitude, the lethargical attitude of the state authorities. Well, is there any explanation on a single line for 3 months or 4 months delay? Nothing. Thereafter, the necessary approval from the competent authority was obtained. When the necessary approval was obtained, nothing. Appellant petitioner herein took necessary follow-up steps to file the appeal against the said judgment order dated such and such. Then, after collecting all necessary papers, handed over to the same learned advocate. Well, where is which date? When necessary steps? When it was given? When LR given the final approval? Nothing. Well, this type of the explanation. Well, I beseech your lordships whether your lordships will allow this type of explanation given by the. And moreover, well, the interesting thing, I do not file a contempt application on it on February. মানে এটা কোথায় আমরা যেগুলো দিয়েছি অপোজিশন yes kindly take our opposition your lordships kindly page 15 opposition filed by us your lordship got it
18
opposition filed
Page
by
15.
Page 15 R1. This is a letter by the district inspector of schools addressed to the HM of the schools. An order has been passed by the Honorable High Court on 16/1/2025 in connection with the above noted writ petition. In this order, there is a direction of the revised pension payment order by taking into renocking the entire service period of the petitioner, Tripti Sarkar Ghosh, ex-HM of your institution, starting from 1/5/1971 to 31st May 2010, along with area amount of the pension. In this regard, you are requested to take necessary steps for compliance of the order of the Honorable High Court within a stipulated time frame. And the petitioner is also requested to cooperate with the said school, supply necessary documents which are requested for movement of the revised pension file. It is at urgent letter to us. When the letter was issued on 24th February 2025, we have not filed any contempt applications. So on 24th, district inspector schools at his own, wrote a letter for compliance of the order. Now on 25th February, the district inspector school wrote a letter that mentioned subject above, HOI is requested to hold the matter until further order. It is 25th February. Now your lordships kindly have a look to the page 17. 27th February, the letter of the senior law officers. 27th February, addressed to the district inspector schools, higher officer of the state, pension department. In reference to the above, they should inform you the photocopy of the above mentioned order has been sent to this good office. Perhaps a copy of the same has been received by you too. The order entirely states, let the revised pension payment order be issued immediately to the petitioner by the respondent number 4 by taking renocking the entire service period of the petitioner starting from May 1, 1971 to the date of superannuation. The petitioner shall be immediately paid within the pension in accordance with law. The area amount of the pension be immediately released to the petitioner. The entire exercise of the above be conduct the said respondent within a period of our
senior law officer.
Senior law officer of the pension department, but he is dealing with this. Senior law
opinion.
Yes, senior law officer is writing a letter.
Legal opinion.
Not a legal opinion. Your lordship kindly say. Hence, you are being the pension sanctioning authority requested to send the revised pension papers to the petitioner of this good officer as early as possible. This may be treated as urgent. It is not a request. It is direction by the senior law officers who is looking after the entire pension. Now your lordships kindly have a look to the next page.
There is the authority, pensioning sanction authority, and director of treasury and provident fund. They are the authority to release.
The district inspector is the pension sanctioning authority. Direction was upon the director of pension. To show director of pension is the revised pensioning, unless the green signal is given by the director of pensions, my lord, the DI will not do anything. And my lord, what does the DI? DI sent a letter for certified copy on 28th 2. Before that, DI has tried, DI has passed an order for compliance. So 28.2, it is not for preferring appeal. It is only for certified copy. You take a steps for having the certified copy.
Certified copy they applied on 4th March.
They applied on 4th March. Right? So, 4th March. So where is the explanation? From January, when they have knowledge on 31st January?
31st January, no, I beg to differ.
31st January, it was communicated.
10th of February. The communication of the London advocate for the Mr. Baris Jr. came to the office of the DI only on 10th of February.
What?
They sent a letter dated such and such when it is received. It is received on 10th of February.
In paragraph 1.
You have written.
কোথায় আছে আমার কোথা থেকে রাখো
Contempt application. Contempt application.
No, contempt কেন? Section 5.
Statements meaning
Paragraph 1 on 31st.
31st, the order was communicated by the advocate. He took gist of the order and communicated.
Yes. He passed by the your petitioner prepared an appeal against the judgment order which was communicated on 31st, 2025. The order was communicated.
Covering letter dated
31st to the office of the district inspector.
Received on 10th February.
And the copy of the order has been received.
10th
February.
10th February, they came to the knowledge. So limitation will start from 10th February.
Yes. If it is a 10th February, I see the 10th February. What steps have been taken up to 16th February?
It was required to be filed within 10th March.
No, if it is a 16th January, then it is required to be filed 16th February.
According
1 month. 1 month. If they applied certified copy, that limitation will run.
When they have applied for certified copy?
The certified copy they applied in the month of March.
4th March.
4th March. What is the explanation? Nothing. And delivery, very interesting thing, delivery of the certified copy on 10th March. And till July, there is no such explanation. From March to July, March, April, May, June, July, no explanation, only for official formalities. That is
what is the reasonable time to be given to LR to take a decision whether appeal
within the limitation period.
Whether appeal should be preferred or not.
Within the whatever action should be taken, that should be within the limitation period. If a officer thinks that he will prefer an appeal after 4 years.
As a private individual can take decision, government cannot take decision in a such manner.
That Supreme Court deprecated.
Private individual can take decision instantly.
That Supreme Court deprecated.
But an authority cannot take.
That is the issue here. And
issue of public exchequer, there is involvement of public exchequer.
That has been decided by 2 coordinate division bench. One, your lordships was the author. I have handed over 2 division bench judgments.
Delhi Development Authority, bench of 3 judges bench.
And Delhi Development Authority was considered by your lordships. Para 14 of the judgment.
Which judgment, Mr. Badi?
I handed up to your lordship.
Development Authority. Delhi Development Authority, 3 judges bench.
The state of West Bengal versus Ubaidullah. Possibly in the file. Lordship got it? MAT 1164. Para 14.
কতদিনের ডিলে ছিল?
252
প্রসেনজিৎ বিশ্বাস হইতে
তো 52
না এটা দেওয়া in that case
এটা বলিনি কেন দিনই কেন এ দুটো দেন
which paragraph you are saying, Mr. Bari?
para 14.
Yes.
Paragraph 10 also, my lord, your lordships can leave.
এটা তো তোমার যেটা প্রপোজিশন ব্রড জেনারেল অ্যাসারশনে যদি হয় সেটা আসবে না। এইটা তো তুমি ওখান থেকে তুলেছো। শোনো, তোমার এখানে it was এখানে মনে হয় order was passed in their presence, in the presence of the applicants requested, para 11. Dated for 22 days.
And my lord, the reply of my lord Justice Chatterjee, my lord, the 2025 4 CHN, the state of West Bengal versus Priya Halder, para 7. হ্যাঁ 2000 না এটা আগের দিন করেছি 2025 ভলিউম 4 CHN, ক্যালকাটা পেজ 219.
This is paragraph?
Para 7. The state is to be treated at par with any other litigant. No special favor is to be bestowed on them while considering the petition for condonation of the delay, merely by virtue of the fact they are the government. The state government has any litigant to explain what sufficient cause prompt them to require the indulgence of the court to condone the delay.
That is what he is distinguishing, Mr. Bari. He says that it can never be treated as par when the quantum of delay is more than 11 years.
No,
in
that
other
is
circumstances,
but
two-digit delay or one-digit delay may not be a substantial fact to be taken into consideration. That is argument.
My lord, the conclusion in Padriya judgments have been given elaborately, what should be. And if your lordship, my lord, what is the explanation? They have given the explanations. From March to July, nothing was said. They said the preparations, they took time.
But what is the guidelines and when one explanation shall be construed to be sufficient and when not?
Well, that is the court will examine.
Whether any state bracket formula can ever be
no, that is the court will examine.
That if the such and such cause is shown, that would be treated as a
that is the entirely.
If such and such cause is not shown, that would not be.
That is the entirely the court will examine. That is the entirely court will examine. So we can submit that there is no such explanations, and it appears from the record.
So the meaning of the word sufficient is to be.
That has been that has been explained by your lordship's judgment.
And sufficient. What is the meaning of the word?
In two coordinate bench judgment, it has been given elaborately.
So what is reasonable and what is acceptable, that is sufficient.
They will have to explain.
Now, if it is found to be reasonable, then it is to be acceptable.
They have to explain that. They have to explain that.
So, government machinery cannot.
They should. They should.
The pragmatic view. Government machinery cannot.
Now the sea change. Now the sea change. It cannot be done. And they should say something. From March to July, they should say something. So no alert took time. No learned advocate took time. Learned advocate was not involved. Within 9 days, it was drafted by Mr. Pal and it was filed. To show what is the explanation of the 6 months? Nothing. Mr. That. Pal Bolam.
এখানে যেটা বলছে
3:30 হয়ে গেল। 3:30 আছে না, 3:30 আছে। A letter for compliance, it is not under threat of contempt. There are other judgment. If under the threat of contempt it is a compliance, it should not be taken into account. But we have not filed in the month of February, March, the contempt application.
observing official जानता चाहिए
Lordship's list since
that hotel employee
hostel employee. They are figuring today, but since there's a early rising.
that was fixed at 2 p.m.
Yes, that was fixed at 2 p.m. Today.
একটা ডেট বলে দাও না কোন
ওকে ওরা বলেছিল যে in another matter went up to the Supreme Court.
Yes.
Have you brought
Yes.
that order?
No.
In one matter, Supreme Court SLP dismissed.
Yes.
And they have said that so the division bench judgment has been upheld. You says that in another matter, division bench dismissed their
That is already in the file.
and that SLP also dismissed
By the writ petitioner. Yes, that is there.
That is in the yes.
We will take up 29th at 2 p.m.
29th at 2 p.m.
এইটা এই বাড়িটার মামলাটা কবে রাতে
একটু কালকে যদি একটু আগের দিকে করে দেওয়ার অনুরোধ রয়েছে মাইলট। ইন পার্সন মাইলট 8 তারিখ থেকে হচ্ছে না মাইলট মামলাটা। মালদা থেকে আসছে মাইলট।
29
18 নম্বর আইটেম মাইলট।
এই শোনো
কালকে একটু আগে দিকে করে দাও।
এটা আমাকে কি বলছে
আজকের 18 নম্বর আইটেমটা ম্যাডাম কালকে ম্যাডাম মাইলট ফিক্স করার অনুরোধ করছি মাইলট। মালদা থেকে আসি মাইলট ইন পার্সন মামলা মাইলট।
কে আপনার অপর পক্ষ কে?
আমার স্টেট
হ্যাঁ,
লান্নার
উকিলের নাম
উকিল হচ্ছে লান্নার চ্যাটার্জি,
কে?
এল চ্যাটার্জি, অমৃতলাল চ্যাটার্জি,
হ্যাঁ
অমৃতালাল চ্যাটার্জি।
আইটেম নাম 18 নম্বর আইটেম।
হ্যাঁ হ্যাঁ, ইন পার্সন মামলা মাইলর, আমি নিজে মাইলর।
আমরা তো বাধিত করেছেন।
রেশন ডিলারশিপের মাইলর।
রেশন ডিলারশিপের মামলা তো আমাদের কাছে পেন্ডিং আছে। সিতারা বেগমের মামলা তো আমরা শুনছি, সেইটা সংক্রান্ত কিছু কি?
না না মাইলর,
সিতারা বেগম সংক্রান্ত নয়, আপনি ঠিক জানেন কি? 2001-এর কন্ট্রোল অর্ডারের বেসিসে?
না মাইলর 2013।
2013-র কন্ট্রোল অর্ডারের বেসিসে। তো সেই 2013-র কন্ট্রোল অর্ডারের উপর সিতারা বেগমের উপর মামলা পেন্ডিং আছে তো। আপনি কি সেটা জানেন? আপনি জানেন সেটা? সিতারা বেগমের যে
অ্যাসোসিয়েশন করেছে,
সিতারা বেগম, হ্যাঁ,
সারা পশ্চিম বাংলার যে ডিলার্স অ্যাসোসিয়েশনরা একটা মামলা করেছে, সেটা পেন্ডিং আছে, তার জন্য অনেকগুলো অ্যাপয়েন্টমেন্ট আটকে আছে। এই বিষয়টা আপনি জানেন?
না মাইলর।
ওটা কবে সিতারা বেগমটা? মামলার নাম্বার আপনাকে দিয়ে দিচ্ছে, আপনি দেখে বলুন ওই মামলার সাথে অন্তর্ভুক্ত কিনা, তাহলে আপনারটা আমরা সেদিনকে শুনবো। ও বলতে পারবে না। করে রেখেছি 5ই ফেব্রুয়ারি। 5ই ফেব্রুয়ারি তো, হ্যাঁ 5ই ফেব্রুয়ারি। এরকম ভাবে তো ডেটটা ফিক্স করতে পারবো না আপনার। আপনি বলতে পারেন কবে আপনি আসবেন না, তাহলে আমরা সেটা রেকর্ড রাখতে পারবো যে আপনার আমার অসুবিধা, আমি এই দিন আসতে পারছি না, বলুন সেটা।
20 তারিখে আসতে পারবো না মাইলর, 19-20।
20 তারিখ, তাহলে আমরা মামলাটা রাখছি 27 তারিখ। আমরা তো আপনাকে ওরকম বলতে পারবো না না যে আপনি 21 তারিখ আসুন, আমরা মামলাটা শুনে নেব।
কালকে একটু আগিয়ে দিলে হয়ে যেত মাইলর।
ওরকম ভাবে তো হয় না, আগিয়ে দেওয়াটা তো নিয়ম নয়।
আর আপনার পাশে যারা আছে তারাই অপোজ করবে যে কেন এমন হলো। দাঁড়িয়ে আছে দেখছেন, এখনো যায়নি।
আমি তো রাত 9টার দিকে জানতে পারছি না মাইলর কত নম্বর সিরিয়ালে, তখনই আমাকে ট্রেনে উঠতে হচ্ছে মাইলর, এটাই সমস্যা আমার।
27 তারিখ করে
আচ্ছা ঠিক আছে, ওটা 27 তারিখ। 27 কিছু মামলা আছে কি? 27 তারিখে তুমি এই গ্রুপ 8-এর ইয়েগুলো উপরে দিয়ে দেবে। 27 তারিখ কোনো টু বি মেনশনড আছে কি? হ্যাঁ, 27 তারিখ গ্রুপ 8 এই গ্রুপ 8-এর মামলাটাও উপরে থাকবে, সেদিনকে আসুন। অপর পক্ষকে জানিয়ে দিন, অপর পক্ষকে চিঠি লিখে দিন।